Hello, everyone. I'm very excited to be here. Thank you, everyone, for joining. It's 12 o'clock, 12:30, 11:30, 11. Look, a variety of different time zones across Australia. Well, thank you for joining. It's an important topic. And I hope you enjoy this new Zoho platform we're on. So today I'm going to be talking about online coaching and clinical practice. It's a major part of how many health professionals are now delivering their services. Psychologists, allied health professionals, doctors, dietitians, fitness and wellness providers are increasingly offering online programs, memberships, group coaching, and one-to-one support through digital platforms rather than through the traditional platforms that we've seen. So this shift is the reason we are doing this webinar today. It's a real opportunity for us to help educate our community about what pitfalls there are, as well as, of course, the pros to it. So I'm going to start with an acknowledgement of country. I would like to acknowledge the traditional owners of the land we meet on today. I'm here on Kaurna land in Adelaide and really want to pay my respects to elders past and present and extend that respect to any Aboriginal or Torres Strait Islander people here today. Thank you for joining. And what's so fun about doing online webinars, I think, is that everybody's coming in from different First Nations lands across Australia. So thank you for joining us from whichever traditional country you're on. Feel free to chat or put things in the Q&A as we go. I will address them when it's appropriate. Thank you. And of course, you'd be disappointed if I'm a lawyer. I didn't start today with a disclaimer, so I will. Of course, I don't want to disappoint you. This presentation is for general guidance only, and legal advice does need to be taken when you're taking actions on specific issues. Who am I? My name's Sarah Bartholomeusz. I'm the founder of You Legal, a law firm that provides legal advice to allied health professionals and doctors, and it's an area I'm particularly passionate about, having come from a family of doctors and allied health professionals. And so hearing about their trials and tribulations and engaging professional services really drives me to protect your businesses and help to create a better health and medical system for all Australians by having health professionals have proper governance documents in place and not have calls like somebody did with one of my colleagues today, where they are getting advice a little bit too late, having agreed to something that they now regret agreeing to and not putting it in writing. Anyway, I could bang on about those things all day. I've also written a book called Growing a Medical Practice from Frustration to a High-Performance Business. That book is just as relevant for allied health professionals. It goes through the regulations that apply to health professionals and gives you ideas about which documents you really do need in place to make sure your practice is protected. As you can see, that is a big focus area of mine, and that's why we're here today. So this webinar is for medical or health or wellness practitioners offering coaching online. That might be nutrition, fitness, lifestyle, or mental well-being. Practitioners or therapists who are integrating online programs into your practice, or AHPRA-related business owners launching membership sites, courses, or coaching packages. By the end of the session, I really hope that you will understand how online coaching is characterised from a legal perspective, recognise the hidden risks that can arise from unclear service descriptions and documentation, gain clarity on the role of properly drafted terms and conditions in protecting your business, and then also building confidence, I hope, in creating ethical, transparent coaching relationships with clients. And why does this matter? Well, online coaching is really central to the business model of many health and wellness practitioners. Programs are delivered at scale, clients may be located across state and national orders, and services are provided outside the context of your traditional patient-practitioner relationship, which you know how that works and you're confident in that. So that's why it's a great idea to be skilling today. Despite the shift, though, there are many practitioners who continue to rely on legal documents that were written for in-person, one-to-one clinical treatments, or not at all, no documents at all. So please don't do that, but it's okay if you do. We are here to help. But the mismatch matters because the law prioritizes substance over labels. It doesn't matter if you call a service coaching if in itself your documents, your marketing language, or your service delivery suggest the service is a healthcare treatment. So when disputes or complaints or dissatisfaction arise, regulators and courts will examine what the client was led to believe that they were receiving. Your personal intention is not the deciding factor. Your client's reasonable understanding based on your representations carries significant legal weight. Failing to address this distinction properly can expose the business or practitioners to a wide range of risks, which include professional complaints. So clients might submit complaints to AHPRA or your board if they feel misled or harmed. Consumer law complaints can also come from this area, and they can arise if services are described inaccurately or outcomes are overstated or impossible to reach. And then there can also be refund disputes, which can be driven by unclear descriptions of what the service does and doesn't provide. Many of these risks aren't obvious at the outset and only surface when a client relationship deteriorates. For instance, a client might not initially perceive a distinction between coaching and treatment, but if they fail to achieve anticipated results, assumptions about clinical outcomes might lead to complaints or legal action. Clear legal foundations reduce the likelihood of such disputes and strengthen your position if issues do arise. Coaching is not the same as clinical practice. From a practitioner's perspective, it can often feel familiar. You're still drawing on your education, experience, and professional knowledge. You might discuss health-related topics, behaviour change, mindset, or well-being goals. The conversations may feel similar to what happens in a consulting room, and the guidance provided may overlap conceptually with clinical advice. However, legally, clinical practice exists within a tightly regulated framework, as all of you know. Clinical services are governed by professional registration requirements, codes of conduct, scopes of practice rules, and regulatory oversights by bodies like AHPRA and the national boards. These frameworks exist to regulate diagnosis, treatment, and therapeutic care. Clinical practice involves legal and ethical responsibilities that include duty of care, informed consent, mandatory reporting obligations, and adherence to professional practice standards. Online coaching, by contrast, is generally not treated as a regulated health service unless it crosses into diagnosis or treatment. Even when delivered by a registered health professional, coaching is usually viewed as a separate category of service. This distinction is critical because when coaching is not clearly distinguished from clinical care, clients might assume protections, outcomes, or obligations that don't actually apply. Misunderstanding this distinction can lead to significant legal exposure, even when the practitioner is highly experienced and well-intentioned. Clinical care carries obligations around documentation, informed consent for treatment, mandatory reporting, and professional insurance coverage. Coaching, by contrast, primarily involves guidance, goal setting, support, and educational or motivational frameworks. While coaching can be informed by a practitioner's professional experience, it doesn't involve diagnosis, treatment planning, or interventions intended to cure or alleviate a medical or psychological condition. Legally, online coaching is generally characterized as educational or guidance-based support. And we know that having groups can really help motivate clients to achieve results that through one-on-one treatment planning in a traditional way might not be available to them. But it really isn't diagnostic in nature. It's not intended to replace medical, psychological, or therapeutic treatment. Instead, coaching focuses on providing information, frameworks, tools, and strategies that clients apply to their own circumstances. Coaching is also typically programmatic. It's delivered through structured programs, modules, group sessions, memberships, or scheduled calls, rather than individually prescribed clinical care. Some personalization might occur, for example, goal setting or motivational support, but it usually doesn't extend to the level of tailored clinical assessment or intervention that would classify the service as regulated healthcare. Coaching is often delivered through an online or digital platform outside the traditional patient-practitioner relationship. As a result, the legal obligations that attach to clinical treatment, such as clinical documentation, requires certain regulatory duties don't automatically apply. However, the distinction only holds if a service is clearly defined and consistently being delivered as coaching. If coaching begins to resemble treatment, regulatory and legal issues can apply. So why does the distinction matter? Well, between coaching and clinical practice, the distinction isn't clearly defined. Clients often fill in the gaps themselves, and they might assume that because you're a registered practitioner, your coaching carries the same responsibilities, outcomes, and protections as clinical treatment. These assumptions are influenced by multiple factors: your qualifications and titles, which might imply clinical authority, the language used on websites, marketing materials, and program descriptions, the structure of sessions, and particularly if they mimic therapy or clinical consultations, the perceived level of personalization, such as one-on-one calls or bespoke guidance, whether boundaries and disclaimers are clearly communicated. Even subtle cues can lead a client to reasonably believe that they're receiving treatment rather than coaching. If something goes wrong, for example, if a client is unhappy with outcomes, feels harmed, or believes advice was inappropriate, these assumptions become central. Regulators and courts will assess whether the client's understanding was reasonable based on how the service was described and delivered. Clear distinctions reduce ambiguity and significantly strengthen your legal position. One of the most common issues that we see legally in online coaching is scope creep. So scope creep can occur when coaching services gradually start to resemble clinical consultations without either party consciously intending on that shift to happen. I switched my slide. Scope creep can happen because sessions feel similar to therapy. Clients seek more personalized advice, or practitioners naturally draw on their clinical instincts to provide guidance. Over time, but boundaries can erode. The service moves closer to treatment without the protections, consent processes, or documentation required for clinical care. Without clearly documented boundaries set out in terms and conditions, onboarding materials, and ongoing communications, it can become very difficult to demonstrate that the service remained coaching and didn't blur the boundaries. Scope creep is rarely obvious at the beginning, but it can become one of the most damaging issues when disputes arise. Some examples might include providing detailed dietary prescriptions or supplement advice beyond general guidance, offering psychological interventions or therapeutic techniques not covered by coaching, assessing or attempting to diagnose underlying medical or psychological conditions, writing personal medical style reports, or progress assessments. So these actions, even if unintentional, can expose the practitioner to regulatory and legal risk if a client later perceives they were receiving clinical treatment. Other hidden legal risks that exist. So beyond the boundary issues, they can be overlooked, and they arise not because coaching is inherently problematic, but because it sits at the intersection of health, business, and consumer law. Many practitioners focus solely on professional regulation, but underestimate their exposure to commercial and consumer law. Others assume that because coaching feels informal and supportive, it carries fewer legal obligations. In reality, online coaching often introduces additional risks due to its potential to scale, digital delivery methods, and client expectations. For instance, an online coaching program may involve multiple participants, often pre-recorded content, rely on third-party software platforms. Each of these elements introduces additional legal considerations related to intellectual property, data protection, liability disclaimers, and terms of use. Understanding these risks early allows practitioners to put safeguards in place proactively rather than reacting defensively after a complaint or dispute has already occurred. Regulators consistently emphasise clarity and accuracy in how services are described and delivered. This applies not only to clinical services, but to health-related coaching offered by qualified practitioners. Regulatory bodies focus on whether marketing materials, websites, onboarding documents, and terms and conditions accurately reflect the nature and limits of the service. If these materials blur the line between coaching and treatment, they might attract scrutiny, even if no harm has occurred. It is important to understand that regulators assess conduct, not labels. Simply calling a service coaching doesn't protect you if the substance of the service suggests otherwise. Regulators look at how sessions are structured, the language included in the emails, contracts, and marketing materials, the expectations set for outcomes and results, and whether personalisation is applied in a way that resembles treatment. Clear, consistent communication across all touch points is crucial. This means that every email, program outline, social media post, and onboard coaching should reinforce that the service is coaching, not clinical care. Practitioners who invest in this clarity are far less likely to face disputes or regulatory scrutiny. Consumer law. So I've mentioned that already. Now I've got a question. I'll just see. Just as a little interjection, if people are coming in late, we will be sending out a recording, provided that this records properly, because this is our first meeting in Zoho. So I'm fingers crossed, Jenna. Thanks for asking. All right, I've mentioned consumer law a few times, and you can see my face. Thank you, Alicia. I didn't know that was going to happen, so I'm sorry for not looking at you. We thought that we weren't going to be looking at you, but you are. So in that case, I'll look at you rather than my other screens. Under the Australian Consumer Law Services, including professional and coaching services, so for professionals in the room, the professional aspect, of course, you will be aware of this, that the Australian Consumer Laws covers this, but you might not have thought about it in terms of coaching services. They need to be provided with due care and skill. They need to be fit for purpose, and they also need to not be misleading or deceptive. These requirements apply regardless of whether the service is clinical or non-clinical, and this means that even if you're a qualified health professional offering coaching rather than treatment, you cannot simply imply clinical outcomes or guarantee results. Doing so may expose you to legal action under consumer law. Common pitfalls can include language that are suggesting that you are guaranteeing results. So, for example, you will lose 5 kilos in 4 weeks, or your anxiety will be cured. Providing overly personalized guidance that resembles treatment rather than coaching. Failing to clarify that clients are responsible for applying information themselves. Consumer law claims can arise even where there's no professional misconduct. For example, a client may allege that the coaching program didn't deliver the promised results or that the marketing materials were misleading. Accurate, clear descriptions of services and disclaimers within terms and conditions reduce these risks and demonstrate compliance. Privacy and data handling. So online coaching frequently involves collecting personal or health-related information. It can include intake forms, questionnaires, emails, messaging platforms, recorded sessions, and video calls, all involving handling sensitive data. Under the Privacy Act, health information is classified as sensitive information and attracts higher compliance obligations. Practitioners must clearly explain what data is collected, health history, dietary habits, emotional well-being, for example, how it will be used, program recommendations, process tracking, for example, where it will be stored, secure servers, encrypted platforms, who has access, for example, practitioners, administrative staff, third-party platforms. And failure to implement robust privacy practices can result in complaints, fines, and reputational damage. It is important as coaching programs scale and involve multiple platforms and third-party tools. So, well-drafting online coaching terms and conditions should reflect both the reality of the coaching model and the legal environment in which health practitioners operate. You would have been disappointed if I didn't talk about this, I'm sure. Key inclusions that we always recommend are a definition of the services stating that it's coaching, not treatment, including your scope and limitations. This is really the boundary. So, in business, setting boundaries is just as important as and I guess I recently did a post on LinkedIn about that. And also, I think airlines, for example, are so good at the scope and limitations. And when running a new business in your existing business like this, it can take a while to figure out what scope and boundaries are appropriate. But setting them out clearly in your terms and conditions is absolutely something you want to do. Setting out what the client is responsible for, acknowledging that they're going to carry their own bags through this process. It's not your job to fix them. Privacy and data handling, because if you're collecting sensitive patient information, you are governed by the Privacy Act, just like your business is. Payment, refunds, and cancellations. How are you going to deal with that if someone's not happy with the service that they've been provided? Having it clearly in your terms is absolutely something you need to do, rather than just playing it by ear if it happens, or hoping that you never get a dispute, which one of my clients, who is a wonderful Pilates instructor and physio, once said. I gave her the risks and she goes, well, I just hope that none of these things ever happen. Well, that's what we all hope for you, but why don't we tighten your terms so that you know what to do if they do? Intellectual property, protecting your content and clarifying what rights your clients have to use it, because we do regularly see other practitioners are offended when other people are using their IP, and rightly so. So making sure that you're asserting a right over that and being clear about how people can use your IP. And then, of course, a dispute resolution, having a process for complaints or disagreements will stop you feeling like you need to respond in a dramatic way if something happens. These elements can help create clarity, reduce misunderstandings, and demonstrate compliance with the consumer law and privacy regulations, including protecting you and separating the business from your clinical practice. So here's a case study on a matter that we assisted with, and I just wanted to sort of explain what it's like to work with us and what can happen when you do like this client did. So it was a doctor who was previously a medical doctor, actually, who came to us, and he wanted to launch an online health coaching platform. It was intended to be non-clinical, and the practitioner wasn't actually registered at all for medical practice, but was mindful of their obligations and their title as a doctor. Initial marketing language and draft documents really did imply clinical expertise and treatment outcomes, and this created the potential for consumer law, regulatory and reputational risks, as well as a potential to get a letter from AHPRA. So we assisted by coaching them to, or advising them to, restructure the service, clarifying the boundaries and aligning the marketing terms with the legal requirements, and then the practitioner was able to launch a compliant programs. So the steps that we took included changing the language to avoid implying diagnosis and treatment, highlighting coaching as educational and goal-focused, creating clear disclaimers in terms and conditions, outlining client responsibilities for applying the guidance themselves, that carry your own bags thing. And this really helps to demonstrate how legal clarity can allow practitioners and former practitioners to operate confidently while protecting both themselves and their clients. I mean, this is just to kind of summarize, I think, why legal expertise is required. It might seem simple, but the reality is far more complex. Health practitioners operate in highly regulated environments that intersect with health law, consumer law, and also privacy law. So without a solid understanding of the legal framework, do-it-yourself documents really can inadvertently expose you to serious risk. Even an well-intentioned disclaimer, if it's incomplete, might fail to protect you if a client misunderstands the nature of the service or claims harm. Health practitioners are already juggling multiple professional obligations, from maintaining ethical standards and scope of practice compliance to managing clinical records and confidentiality requirements. You do have significant responsibilities. Adding online coaching to the mix does increase complexity, particularly when services are delivered digitally or to clients across digital jurisdictions. It is, of course, a wonderful way to increase your impact. And I'm not trying to talk you out of it. I think that it is a wonderful addition to many people's practices, but I do suggest investing in professional guidance up front to help protect your business. Legal clarity also helps with ethical practice. When your clients understand the boundaries and limitations of your service, they can engage confidently and make more informed decisions about their participation, which creates a more sustainable coaching business for you as well. What I'm hoping you've got as key takeaways are that online coaching is legally distinct from clinical practice. Even if you're a registered health professional, offering coaching doesn't automatically fall under clinical regulation, providing the service is clearly framed as educational or guidance-based rather than diagnostic or treatment-oriented. Blurred boundaries between coaching and clinical practice do create significant risk. Having clear terms and conditions will protect all privacy policies, of course, disclaimers. They're essential tools for mitigating these risks. A well-documented legal framework will ensure your coaching business operates transparently, ethically, and confidently, supporting long-term growth and sustainable client relationships. So what can you do? Here's a stepwise. If you currently offer or plan to offer online coaching, there are practical steps you can take. And you can start by reviewing your existing documents, including terms and conditions, privacy policies, and onboarding materials and marketing materials, of course. Check whether they reflect the boundaries. Look at your privacy compliance. review your terms, or if you haven't got them, have some drafted. Seek expert legal advice and guidance. Professional advice will ensure that your terms are robust, reduce your risk, and allow you to operate your coaching business confidently and sustainably. Our team has extensive experience assisting online coaches in their legal framework, and we suggest that you book a call with Daniela, one of our senior lawyers. She is a delight to talk with, and honestly, it makes her day talking to you guys. She can help guide you on what the next best steps are for your coaching business. So highly recommend you book in with Daniela. We'll send out that link. We might put it in the chat for you now as well. And I think I've got a little bit of time for questions. These are my contact details if you want to screenshot them as well. And we do have a Facebook group, You Legal for Doctors, which is a wonderful community that we have where people can ask questions or ask for resources. Use our resources in there as well. All right, questions. Monica, you're a nurse and see that we marketed to allied health professionals. Very relevant for nurses. Thank you. I will make sure that nurses know that this is relevant material for them. So thank you so much for turning up and for that feedback. That is wonderful. Any other questions? I know we're out of time, but I'm here. I will hang around if anyone has any other questions. Otherwise, we'll finish up and we'll get the recording out to you so you can send it off to people that you think might benefit from it in the meantime. And looks like no one's putting questions yet, which is fine. We know that the chat works, which is part of the stress when you're starting to use a new platform. And we'll get the slides in a PDF out to you as well, so you can check out that again in your own time. Thank you everyone for turning up, and I look forward to seeing you next month. Our next webinar is about international medical graduates, and it's actually a collaboration with an immigration lawyer and a recruiter as well. So you will see that marketing come through, I'm sure, and we look forward to keeping in touch with you. Thanks for coming along.